This is the Ministry of Truth. I'm Gordon Comstock. Time to close out the online book by James Montgomery entitled The United States is Still a British Colony. This is the last chapter, chapter 7. It's part 2 of the last chapter. This chapter entitled American Land Ownership, a True Oxymoron. Plan of a New Government. Our forefathers were first and foremost administrators for the king and his holdings, so as to keep their personal grants and fee-simple titles to their own land holdings in America and Britain. Prior to the Revolutionary War, the 1783 Peace Treaty, and the 1787 Constitution, there was a plan to organize a central government still subject to the king, still collecting taxes for the king. The only difference between the government we have and the government you read about below is your perception, with word and technical changes. The 1787 Constitution was a well-thought-out document, but the document below was its predecessor, and the similarities are obvious. What you will read below, along with the other documents provided in this book, describe exactly what we have today. Notice the 2 paragraphs provided below. In the first, a central government is to be set up, with each colony to retain its own constitution. In the second paragraph, you see that a President General is to be elected to run the central government for the king. What do we have now? President Commander-in-Chief. Also, he is appointed and supported by the Crown. How does any president get elected? The system is set up so that only someone supported by the large corporations of this country can seriously run for president or be elected because of their financial support. Without this support, you cannot be president, no matter what the public wants. So the public only has Crown-approved men they can select from to vote for. That way, no matter who wins, the Crown's interest is protected. The public is told what to think about the different men the corporations have chosen to represent them, so they think they are making informed choices. Nothing could be further from the truth. They are electing a man, no matter the party, that will protect the Crown's interest, not the public's. You may wish to continue to deny reality, but you can't separate the wet from the water, nor separate our government from Britain. The following is from the Constitution's predecessor, and here it's all laid bare. The 1754 Albany Plan of Union. Quote, "It is proposed that humble application be made for an Act of Parliament of Great Britain, by virtue of which one general government may be formed in America, including all the said colonies, within and under which government each colony may retain its present constitution, except in the particulars wherein a change may be directed by the said act, as heretofore follows. That the said general government be administered by a President General, to be appointed and supported by the Crown, and a Grand Council to be chosen by the representatives of the people of the several colonies met in their respective assemblies." Unquote. That was from the 1754 Albany Plan of Union. The King's corporations are alive and well. Lands they hold in fee simple can be parceled out to whom they will, with the lands returning to the king when the grant/trust/license expires. The king made grants to his colonies and lords. They became corporations under the United States Corporate Charter. The lords make grants to other select men via corporate charters or by grants of trusts or license to smaller corporations and individuals. Any time a corporation dies and no office is found, its lands revert back to the grantor of the corporation, and so on back up the line. This is the reason for the inheritance tax and why it will never be repealed. I refer you to an earlier chapter I wrote entitled, How Long Can a Corporation Live? Also, check out a paper the Informer and I jointly wrote on the subject of rent roll and reversion and corporation soul, entitled Friends, Enemies, and Die-Hard Doubters. And you would be well advised to read the Informer's book, The New History of America, and his other publications. Before you read the ancient statutes, you must understand the legal term fee simple. Understanding fee simple. The following is from Blackstone's Commentaries. Quote, 63. 1. Origin of feuds. The constitution of feuds had its original from the military policy of the northern or Celtic nations, the Goths, the Huns, the Franks, the Vandals, and the Lombards, who, all migrating from the same officina gentium, the storehouse of nations, as Cragg very justly entitles it, poured themselves in vast quantities into all the regions of Europe at the declension of the Roman Empire. It was brought by them from their own countries and continued in their respective colonies as the most likely means to secure their new acquisitions. And to that end, large districts or parcels of land were allotted by the conquering general to superior officers of the army, and by them dealt out again in smaller parcels or allotments to the inferior officers and most deserving soldiers. These allotments were called feoda, feuds, fiefs, or fees, which last appellation in the northern languages signifies a conditional stipend or reward. Rewards or stipends they evidently were, and the condition annexed to them was that the possessor should do service faithfully, both at home and in the wars, to him by whom they were given, for which purpose he took the jurentum fidelitatis, or oath of fealty, and in case of the breach of this condition and oath, by not performing the stipulated service, or by deserting the Lord in battle, the lands were again to revert to him who granted them, unquote. The following is from Black's Law Dictionary, 4th edition, 1968. Quote, feud, an inheritable right to the use and occupation of lands, held on condition of rendering services to the lord or proprietor, who himself retains the property in the lands, unquote. The following is from the publication Feudalism by F.L. Ganshoff from 1964. Quote, thus the people had land they occupied, devised, inherited, alienated, or disposed of as they saw fit, so long as they remained in favor with the king, unquote. The following is from Ballantyne's Law Dictionary, 3rd edition, 1969. Quote, the largest estate in the land known to the law and implying absolute dominion over the land. An estate of inheritance clear of any condition, limitation, or restriction to particular heirs. 28 American Jurisdiction to establish 10. An estate of lawful inheritance or pure inheritance, fee standing for inheritance, and fee simple for pure or lawful. A legal or equitable estate in land constituting the largest estate and implying absolute dominion, although possibly subject to executory limitations or conditions subsequent. Hayes Estate versus Commissioner. Ford versus Unity Church Society. Unquote. The following is from the website ohiobar.org. Are taxes to be paid by common man holding fee simple title? Yes, according to the way fee simple is defined today. Today, fee simple has been reduced in status to fee tail for common man. He is to pay all land taxes. Also, he must abide by all restrictions placed on the land by federal, state, and local governments, nor can he use the land in any activity contrary to the public policy. The difference is the U.S. corporation, just as the knight was granted land for fee, in service of the king by grant. Common man receives their fee from the corporation in tail, a lesser title. Today, fee simple and fee tail are synonymous depending on your status. I would have placed the quote here from the Ohio Bar Association on fee simple, but they restrict its use. However, below is their website so you can look for yourself. The following is from I.E. Washburn's Treatise on the American Law of Real Property. Allodial and Land Patents Titles. Quote, this holding of lands under another was called a tenure, and was not limited to the relation of the first or paramount lord and vassal, but extended to those to whom such vassal, within the rules of feudal law, may have parted out his own feud to his own vassals, whereby he became the mesne lord between his vassals and his own or lord paramount. Those who held directly to the king were called his tenants-in-chief. Unquote. Maybe with the below quote, you will also understand the meaning and significance behind the pyramid on our dollar, with the all-seeing eye at the top of the pyramid. The following is from F. Goodwin, Treatise on Law and Real Property, Allodial and Land Patents Titles. Quote, the fiefs were built in the same manner as the pyramid, with the king, the true owner of the land, being at the top. And from the bottom up there existed a system of small to medium-sized to large-sized estates, on which the persons directly beneath one estate owed homage to the lord of that estate as well as to the king. At the lowest level of this pyramid, through at least the 14th and 15th centuries, existed serfs or villains. There you go, Ev. The class of people that had no rights and were recognized as nothing more than real property. Unquote. The following is from Gilsebert of Mons. Chronicle, Allodial and land patents titles. Quote, under this type of fief, a certain portion of the grain harvested each year would immediately be turned over to the Lord above that particular fief, even before the shares from the lower lords, and then serfs of the fief would be distributed. A more interesting type of fief, for purposes of this memorandum, was the money fief. In most cases, the source of money was not specified, and the payment was simply made from the fief holder's treasury. But the fief might also consist of a fixed revenue to be paid from a definite source in annual payments in order for the tenant owner of the fief to be able to remain on the property. Unquote. The following is from Blackstone's commentary, Book 2. Quote, 142. 1. Fee simple estates. Tenant in fee simple, or, as he is frequently styled, tenant in fee, is he that hath lands, tenements, or hereditaments to hold to him and his heirs forever, generally, absolutely, and simply, without meaning what heirs, but referring that to his own pleasure or to the disposition of the law. The true meaning of the word fee, or feodum, is the same with that of feud or fief, and in its original sense it is taken in contradistinction to allodium, which latter the writers on this subject define to be every man's own land, which he possesseth merely in his own right, without owing any rent or service to any superior. Unquote. The following is from Windle versus Crandall, 1848. Quote, thus, the term fee simple absolute in common law England denotes the most and best title a person could have, as long as the king allowed him to retain possession of or own the land. It has been commented that the basis of English land law is the ownership of all reality by the sovereign. From the crown, all titles flow. The original and true meaning of the word fee, and therefore fee simple absolute, is the same as fief or feud, this being in contradiction to the term allodium, which means or is defined as a man's own land, which he possesses merely in his own right, without owing any rent or service to any superior. Unquote. The following is from Friedman versus Steiner, 1883. Quote, therefore, on common law England, practically everybody who was allowed to retain land had the type of fee simple absolute often used or defined by courts. A fee simple that grants or gives the occupier as much of a title as the sovereign allows such occupier to have at that time. The term became a synonym with the supposed ownership of land under the feudal system of England at common law. Thus, even though the word absolute was attached to the fee simple, it merely denoted the entire estate that could be assigned or passed to heirs, and the fee being the operative word. Fee simple absolute dealt with the entire fief and its divisibility, alienability, and inheritability. Unquote. The following is from Gilsebert of Mons, Allodial and Land Patents Titles. Quote, if a fee simple absolute in common law England denoted or was synonymous with only as much title as the king allowed his barons to possess, then what did the king have by way of a title? The King of England held ownership of land under a different title and with far greater powers than any of his subjects. Though the people of England held fee simple titles to their land, the king actually owned all the land in England through his allodial title. And though all the land was in the feudal system, none of the fee simple titles were of equal weight and dignity with the king's title, the land always remaining allodial in favor of the king." Unquote. The following is from Stanton versus Sullivan, 1839. Quote, "Thus, it is relatively easy to deduce that allodial lands and titles are the highest forms of lands and titles known to common law. An estate of inheritance without condition, belonging to the owner and alienable by him, transmissible to his heirs absolutely and simply, is an absolute estate in perpetuity and the largest possible estate a man can have, being in fact allodial in its nature." Unquote. The law of mortmain, law of the sovereign, protecting his lands held by his lords and religious men in fee, prohibiting them from diluting his title, declaring he could confiscate the land he or his lords were alienated from. Even the lords were subject to have their land reclaimed by the king if they violated the king's license requirements. You can find the law of mortmain at the end of the chapter in the quotes section. I want to make this clear. If the king and his law, i.e. common law, are still alive, then so are his charters, corporations, and trusts. Without defeating the king through death or removal, his law still exists. If his law still exists, his corporation, the crown, is, as I have said, alive and well. What did we do at the end of the Revolutionary War and in framing the 1787 Constitution? Claim the king's law, his common law, his feudal law for our own, and made it our law. So, if you are subject to any tax on the land you live on, you do not, I repeat, do not own your land. You do not have a allodial title to your land. It is not possible. Allodial and taxed property are an oxymoron. The two are as opposite as light and darkness. The two cannot exist together. Even worse than this, under common law, which we made our law of the land, you do not even have fee simple possession of your land, because early fee simple possession is free from taxation. You hold the land in fee simple at best if you have a tax shelter, a trust. Fee tail and lesser ownerships are evidenced by a title, deed, or mortgage, which is how most land is held and is subject to taxation and or repossession if the taxes are not paid. I'm sorry, but this is a fact. I don't care what you've been told or led to believe concerning allodial title. A huge number of patriots believe, because of the Declaration of Independence and the Revolutionary War, that we are sovereigns here, possessing the land through allodial title, as a matter of sovereignty, by having defeated the king. Wrong. It is impossible. The king has conned Americans. Or, I should say, allowed them to believe they are sovereigns, owning their land through allodial title. This would be a good place for you to read some quotes by Sir Edmund Burke and by Adam Smith, because of the importance taxation plays improving land ownership in America by allodial title is an oxymoron. I'm including more quotes at the end of this chapter by Adam Smith and other relevant information. Okay, we're going to skip a bit here. James Montgomery has a lot of quotes, disparate quotes from Adam Smith and from more court cases regarding allodial title. I want to read this short one here. It is by Sir Edmund Burke in 1775 in Britain. Said this before the House of Commons. Today we're told that Edmund Burke, during the Revolutionary War, he wanted Britain to let America go because they had British blood in them. Of course they're going to fight us. We need to be friends with them and just trade with them. Yeah, he said that, but it wasn't because of the story we're told that he had feelings for the Americans. He was thinking only in terms of profit, folks, and in terms of enriching the crown, his lord. Here's what he said, quote, "But my idea of it is this, that an empire is the aggregate of many states under one common head, whether this head be a monarch or a presiding republic," unquote. And then James Montgomery writes, "So, that explains Benjamin Franklin saying, 'We have given you a republic, if you can keep it.' Actually, what Franklin said meant nothing. It was not a hindrance to the king and his barristers. The republic was not a hindrance to the king and his lawyers." Boy, a lot of legal court sightings here, skipping forward. This is back to the words of James Montgomery. "Then, confirmed by the 1783 Paris Treaty, or Peace Treaty, wherein the minerals did not change hands. They stayed with the king, his heirs and successors. In other words, the king, his heirs, and his successors forever were to continue to receive, as a matter of trust, the gain and profit from his corporate venture. To cement this, since his subjects had gone brain dead and now believed themselves free from their obligations, believing when the states became states of, after the 1787 Constitution was ratified, they believed they became free and sovereign. In March 1791, thanks to good old George Washington, the states of became district states of the Crown, sidestepping even the 1787 Constitution and the states' short-lived independence that had been declared in 1776. In favor, now, of the king's public policy, his taxes and licenses to be administered by his United States Corporation and its elected fiduciaries and den of thieves. When governing for the king, the President and Congress were no longer bound by the 1787 Constitution. Not since 1791. The king would now receive, as declared in his early charters for himself, his heirs, and successors, the 30% tax for his family business venture. Because now his bank could operate within the several district states incorporated in the District of Columbia. This was not possible until Washington made the district states in 1791, never to be repealed. Skipping forward, more and more citations. James Montgomery apparently did at least a decade's worth of work, painstaking work in law libraries to uncover all of this. If you want to read all of these quotes, go. I have the link up. Go read it. Okay, getting back now. This looks like the words of James Montgomery again. Okay. His words are interspersed now in between just voluminous quotes. The main thing I want you to understand, and I believe most do, as I said earlier, our laws were based on the common law of England, All states in union of the United States are, except one. That's right, one state out of the 50 is not under English common law. A lot of you may think this must be Texas, but it is not. The one state not subject to or formed under English common law is New York. New York City is responsible for not only our demise, but the entire world's. Boy, if you ever had a doubt about New York representing some kind of Babylon, if not the Babylon of the book of Revelation, listen up to this. New York City is the alter ego of London and the other banking centers for the banksters of the world to operate. New York City is the home of the bankers, the World Trade Center, the stock market, the World Bank's control via the IMF and the United Nations, etc. The controlling center for all banking, communication, and supercomputers containing data on everyone and every transaction for the bankers to control the world's population and their leaders through their finances, with the UN as their police force and NATO as prosecutor of the law of the flag and conqueror of new empires. When you read the very revealing statements in the New York statutes below, you will see they declare themselves not to be under English common law. If you would like to understand how this fits into God's Word, that is New York City, here we go. Read James Montgomery is thinking like I'm thinking. Read Revelation 17 and 18, Jeremiah 51, and Isaiah 13. I wrote on this subject years ago, and I won't go into it here other than to say, New York City is the biblical Babylon, as you can read for yourself, as God Almighty defines Babylon in Revelation 18. No other city in the world meets his definition. Okay, so just to prove if he was right, let's read this quote here he has from New York State Consolidated Laws, General Construction, Article 3, Ancient Statutes and Resolutions, quote, Section 70, Statutes of England and Great Britain inoperative in this state. James Montgomery was not kidding. 71, Acts of the Legislature of the Colony of New York inoperative. 72, Resolutions of the Congress of the Colony and the Convention of New York inoperative. Section 70, Statutes of England and Great Britain inoperative in this state. And it just goes on, just a few more. There it is. He was right. Boy, this guy excavated all of this stuff. Wow, it must have really taken a lot of lonely hours. Lonely, boring hours to find this stuff. Okay, skipping forward, more and more and more citations, and now we get back to the words of James Montgomery. I guess now is a good time to deal with the pipe dreams we have been taught and allowed to believe, reinforced by the government's school system in the selective teaching of history and also parroted by the media. The pipe dream, as I said earlier, is our belief that we do or can possess land in this country under the present law in allodial title. Notice I said under the present law. This is the key to the king's power, retaining possession to his corporation, the crown. What did we do at the beginning of this nation? Declare our law to be English common law, confirming the king's corporation and the law that created it and protects it even today. And the following, there's a bunch of quotes about law quotes from law dictionaries about definitions about a corporation, corporation sole, reversion, civil corporations, dissolution of corporations. We'll skip that and get back to James Montgomery again. Not to get ahead of myself, he writes, we first declared our independence. That sounded good. But why would you place your neck back under the yoke, the law that subjected you? Simple. As history proves, many of our forefathers, including Washington, did not want to be separated from the king. Some stood to lose lands and title. Others understood they were subjects of the king and they liked it. History shows they were not at odds with being subjects of the king, just his policies regarding taxes and their government being so far removed. Commerce and legal convenience demanded representation here, but still controlled by the king. The king, being so far removed from his possessions in America, misjudged his subjects' needs, and rebellion turned into war. But as always, the belligerents just wanted their redress heard, and our forefathers, knowing full well English history and how the game was played, knew the king would capitulate and make the concessions needed, never dreaming they would have what appeared to be a separate sovereign country at the end of the war. What about this war? Did we win? Well, let's look at history. I have covered this before, but it bears repeating. Cornwallis surrendered at Yorktown, but the document read, "Capitulation at Yorktown." Did Cornwallis surrender, or did they just quit fighting because the king made the necessary capitulations to the colonists' demands? Well, did Cornwallis surrender his arms, in other words? Did he and his troops lay down their arms and leave unarmed? No. Did Cornwallis surrender his colors, the king's flag? No. Anyone that knows anything about war and conquest knows the flag of the surrendering enemy has to be surrendered. If not, you just fought a battle. You did not win the war. Was Cornwallis and his army allowed to return to England armed and with their colors? Yes. Were British subjects allowed to retain their lands and possessions in America? Yes. Was the king removed from his throne and his laws defeated by his removal? No. Tell me again, America, we won the Revolutionary War? I'm sorry, the facts don't support what you want to believe is the case. Now to the so-called 1783 peace treaty, wherein the king's possessions were turned over to us without his losing the war. Benjamin Franklin spent almost the entire war traveling back and forth from France and England, working out the terms of the treaty, the grant from the King of England. Let me see. We did not win the war. We did not dictate the terms of surrender. The king's barristers, along with the esquires chosen from America, esquire being a title of nobility subject to the king, Franklin, Jay, and Adams, wrote the document. A document wherein the king's law remained in force, and he granted lands to his new corporation, the United States. However, he did not grant to his corporation the rights to the minerals existing and all to be found in the future. As I have said before, he declared in his charters ownership to all minerals, and that he was to receive a portion of the gain and profit in this country forever. Go back and read the quotes earlier in this paper. Also, how can the king do anything else but give fee simple title when his law provides for only him to have allodial title? Did he change his law? No. Could he change the unrevocable trust his charters established for all his heirs and successors? No. No, and could not, without destroying his throne, his crown, his corporation, and his law, thereby conquesting himself. You see, that is the only way under the king's law to own land by allodial title, via conquest, as the conqueror. This is why no country has defeated the King of England and his crown, because if his law exists, wherein the corporate charter was created, and the king and his heirs remain, the king's crown and charters remain in force. Here are some highlights from some quotes here by Frederick Maitland, that whoever this guy is. 1901, Frederick Maitland. The book is called The Crown as Corporation. I'll just read to you some salient bits that I've highlighted. Quote, some corporations are made by the king, others by the pope, others by both king and pope. Skipping forward. The king, he and his subjects together compose the corporation. He is incorporated with them, and they with him. He is the head, and they are the members, and he has the sole government of them. Skipping. His Majesty, his heirs and successors in his politic capacity, which in consideration of law never dies. Skipping forward. The public first becomes prominent in connection with the national debt. Skipping forward, some proceedings of one of his predecessors who closed the exchequer and ruined the goldsmiths had made our king no good borrower, so the public had to take his place. The money might be advanced to his Majesty, quote unquote, but the public had to owe it. This idea could not be kept off the statute book. Whereas, said an act of 1786, the public stands indebted to the East India Company in a sum of 4 millions and more. Skipping forward, we may trace the beginnings of a national debt back to days when a king borrows money and charges the repayment of it upon a specific tax. Of course, what did Samuel warn the Israelites about kings? Skipping. But then comes the lawyer with theories in his head and begins placing a legal estate in what he calls the crown or her majesty. Skipping forward, unquote there. This looks like, back to the words of James Montgomery. Even the Postmaster General was used to secure the king's possessions in America, and was a vehicle used by the king through the president and his powers as commander-in-chief to expand the king's land west, via the king's law going west with the laws governing the mail. After that is a quote from President Monroe arguing that such powers were not being used and did not exist. He would no doubt have to eat a huge amount of crow today, if he was alive today, and saw the Department of Transportation and the power they have been granted over the nation's roads and skies. He will also see the need for the king to incorporate, and that a grant of sovereign land ownership was given to the War Department. Sounds like a military's loyalty was bought and paid for, leading up to conquest of America after the Civil War. The following is from Frederick Maitland, again, 1901. Quote, in 1840, the Postmaster General and his successors is and are made a body corporate for the purpose of holding and taking conveyances and leases of lands and hereditaments for the service of the post office. From the act that effected this incorporation, we may learn that the postmaster, as a mere individual, had been holding land in trust for the crown. One of the main reasons, I take it, for erecting some new corporation's soul was that our crown, being more or less identifiable with the king, it was difficult to make the crown a leaseholder or copy holder in a direct and simple fashion. Okay, skipping forward, there's a lot more here, but it's all citations from law libraries that James Montgomery dug up. This is interesting. I highlighted this. Let's see. This comes from, looks like Blackstone Commentaries, Book 3, page 1554. 5. Quote, "The Federal Reserve, sister of the Exchequer." Is that really from that? No. This is from Ballantyne's Law Dictionary. Quote, "Exchequer, the English Department of Revenue, a very ancient court of record set up by William the Conqueror, intended principally to order the revenues of the crown and to recover the king's debts and duties. It was called exchequer from the checked cloth resembling a chessboard which covers the table." Unquote. This is from Black's Law Dictionary, 4th edition. Quote, "Exchequer, that department of the English government which has charge of the collection of the national revenue, the Treasury Department." Unquote. This is from Bouvier's Law Dictionary. Quote, "Exchequer, in English law, a department of the government which has the management of the collection of the king's revenue." All right. So again, Montgomery writes about that. The Federal Reserve is the sister of the Exchequer of Britain. Oh, wow. Montgomery includes here the definition of a legal fiction and how it relates to being a corporation and not a person. Then he includes the Statute of Mortmain from 1279, which declares that the king could never make treaties which would give up any claim of his posterity, ever. Oh, boy. Is that it? Wow. He's got a citation here from 1992. An executive order that further proves the American people do not own any land in America. Wow. Okay, well, skip that. Oh, boy. And then here, he's got a citation, a footnote, from a Senator Owen in the Congressional Record of 1916. Holy mackerel. I think I need to read this. Senator Owen, quote, "This holy alliance, having put a Bourbon prince upon the throne of France by force, then used France to suppress the condition of Spain immediately afterwards, and by this very treaty gave her a subsidy of 20 million francs annually to enable her to wage war upon the people of Spain and prevent their exercise of any measure of the right of self-government. The Holy Alliance immediately did not do the same thing in Italy by sending Austrian troops to Italy, where the people there attempted to exercise a like measure of liberal constitutional self-government." If you've read the works of Chuck Wilcox, you know where this is going. "And it was not until the printing press, which the Holy Alliance so stoutly opposed, taught the people of Europe the value of liberty, that finally one country after another seized a greater and greater right of self-government, until now it may be fairly said that nearly all the nations of Europe have a very large measure of self-government." Not anymore. "However," says Senator Owen, "I wish to call the attention of the Senate to this important history in the growth of constitutional popular self-government. The Holy Alliance made its powers felt by the wholesale drastic suppression of the press in Europe, by universal censorship, by killing free speech and all ideas of popular rights, and by the complete suppression of popular government. The Holy Alliance, having destroyed popular government in Spain and Italy, had well laid plans also to destroy popular government in the American colonies, which had revolted from Spain and Portugal in Central and South America under the influence of the successful example of the United States. It was because of this conspiracy, yes, he used the word conspiracy, folks, this conspiracy against the American republics by the European monarchs, that the great English statesman Canning called the attention of our government to it, and our statesmen then, including Thomas Jefferson, who was still living at that time, took an active part to bring about the declaration by President Monroe in his next annual message to the Congress of the United States that the United States would regard it as an act of hostility to the government of the United States and an unfriendly act if this coalition or if any power of Europe ever undertook to establish upon the American continent any control of any American republic or to acquire any territorial rights. This is the so-called Monroe Doctrine, the threat under the secret Treaty of Verona to suppress popular government in the American republics is the basis of the Monroe Doctrine. Boy, we're never told that. Never, never in American schools. This secret treaty sets forth clearly the conflict between monarchical government and popular government, and the government of the few as against the government of the many. Unquote, that from Senator Owen, Congressional Record, 1916. And then he includes a footnote, a certain oath to a certain secret society. That is a very vicious and bloodthirsty oath. Okay, folks, that concludes. The United States is still a British colony. In this last chapter, American Land Ownership, a True Oxymoron. This work by James Montgomery. You can access it. Go to his site from the link I'll put up. I'm Gordon Comstock. This has been the Ministry of Truth. Over and out. Grant/trust/license expires. The king made grants to his colonies and lords. They became corporations under the United States Corporate Charter. The lords make grants to other select men via corporate charters or by grants of trusts or license to smaller corporations and individuals. Any time a corporation dies and no office is found, its lands revert back to the grantor of the corporation, and so on back up the line. This is the reason for the inheritance tax and why it will never be repealed. I refer you to an earlier chapter I wrote entitled, How Long Can a Corporation Live? Also, check out a paper the Informer and I jointly wrote on the subject of rent roll and reversion and corporation soul, entitled Friends, Enemies, and Die-Hard Doubters. And you would be well advised to read the Informer's book, The New History of America, and his other publications. Before you read the ancient statutes, you must understand the legal term fee simple. Understanding fee simple. The following is from Blackstone's Commentaries. Quote, 63. 1. Origin of graphs provided below. In the first, a central government is to be set up, with each colony to retain its own constitution. In the second paragraph, you see that a President General is to be elected to run the central government for the king. What do we have now? President Commander-in-Chief. Also, he is appointed and supported by the Crown. How does any president get elected? The system is set up so that only someone supported by the large corporations of this country can seriously run for president or be elected because of their financial support. Without this support, you cannot be president, no matter what the public wants. So the public only has Crown-approved men they can select from to vote for. That way, no matter who wins, the Crown's interest is protected. The public is told what to think about the different men the corporations have chosen to represent them, so they think they are making informed choices. Nothing could be further from the truth. They are electing a man, no matter the party, that will protect the Crown's interest, not the public's. You may wish to continue to deny reality, but you can't separate the wet from the water, nor feuds. The constitution of feuds had its original from the military policy of the northern or Celtic nations, the Goths, the Huns, the Franks, the Vandals, and the Lombards, who, all migrating from the same officina gentium, the storehouse of nations, as Cragg very justly entitles it, poured themselves in vast quantities into all the regions of Europe at the declension of the Roman Empire. It was brought by them from their own countries, and continued in their respective colonies as the most likely means to secure their new acquisitions. And to that end, large districts or parcels of land were allotted by the conquering general to superior officers of the army, and by them dealt out again in smaller parcels or allotments to the inferior officers and most deserving soldiers. These allotments were called feoda, feuds, fiefs, or fees, which last appellation in the northern languages signifies a conditional stipend or reward. Rewards or stipends they evidently were, and the condition annexed to them was that the possessor should do... This is the Ministry of Truth. I'm Gordon Comstock. Time to close out the online book by James Montgomery entitled The United States is Still a British Colony. This is the last chapter, chapter 7. It's part 2 of the last chapter. This chapter entitled American Land Ownership, a True Oxymoron. Plan of a New Government. Our forefathers were first and foremost administrators for the king and his holdings, so as to keep their personal grants and fee-simple titles to their own land holdings in America and Britain. Prior to the Revolutionary War, the 1783 Peace Treaty, and the 1787 Constitution, there was a plan to organize a central government still subject to the king, still collecting taxes for the king. The only difference between the government we have and the government you read about below is your perception, with word and technical changes. The 1787 Constitution was a well-thought-out document, but the document below was its predecessor, and the similarities are obvious. What you will read below, along with the other documents provided in this book, describe exactly what we have today. Notice the two paragraphs separate our government from Britain. The following is from the Constitution's predecessor, and here it's all laid bare. The 1754 Albany Plan of Union. Quote, "It is proposed that humble application be made for an Act of Parliament of Great Britain, by virtue of which one general government may be formed in America, including all the said colonies, within and under which government each colony may retain its present constitution, except in the particulars wherein a change may be directed by the said act, as heretofore follows. That the said general government be administered by a President General, to be appointed and supported by the Crown, and a Grand Council to be chosen by the representatives of the people of the several colonies met in their respective assemblies. Unquote. That was from the 1754 Albany Plan of Union. The King's corporations are alive and well. Lands they hold in fee simple can be parceled out to whom they will, with the lands returning to the King when the